engamoya engcwele Thixo namandla amakhulu that xa sizawuthetha misiyona amandla amakhulu makuthethe wena Thixo usebenzise usisi uNcumisa kule ncoko ufuna uba sive. Allow your people, Lord, allow your children to hear you, not only to hear what is going to be spoken, but also to heed what is going to be spoken. Heavenly Father, please cover Usisi Ncumisa as she shares her gifts and her skills with us and her knowledge, mighty God. Please lead her as she does your work. Heavenly Father, we thank you for this platform. We thank you for all the people that give of themselves in order for us to grow and in order for us to learn. Heavenly Father, I pray that you be with everybody who's going to connect, whether they connect live or they view this recorded video. Mighty God, I pray that you be with them, that they may learn something. I pray in the name of the wonderful Lord, your Son, Jesus Christ. Amen.
Amen.
So as I've said, friends, on this Thursday evening, we are being visited by Usis Ncumisa, who is going to talk about protect your family, know why it is important to have a will. And I'm going to read a little bit of her biography. Ncumisa Nongongo holds a B.Juris and LLB degrees from the University of Transkei, now WUSU, and the University of Natal, now UKZN, respectively. She was admitted as an attorney in 1997, and she has been practicing for her own account as a partner and then director at Malusi and Company Attorneys in East London since 2004. In 2007, she was admitted as a conveyancer. She runs a general practice covering most areas of the law. She is passionate about access to the profession by women and training and mentoring of young lawyers. She has been an instructor at Lead for over 10 years. She has been involved in the governance structures of the legal profession and is the chairperson of the Eastern Cape of the Legal Practice Council. She is also a member of the National Executive Committee of the National Association of Democratic Lawyers. She also is an active member of the South African Women Lawyers Association, whose objectives are to facilitate the full participation of women in the legal profession. She participates in the access of justice activities by providing free services to communities in our rural areas of the Eastern Cape. Wow, this is what I call Mbokoto. Welcome, Sis Ncumisa. Thank you so much for your time.
Thank you so much, Yalelo, for your kind introduction. I hope I'm pronouncing your name correctly. It is pleasure to be
But call me Sly. I think everybody on this platform knows that we are now friends, so you can easily, and I can gladly allow you to call me Sly.
Thank you. So good evening to everyone. Thank you very much for inviting me to this platform. And I hope that what we will share is indeed going to benefit all of you. As I said earlier on, I will just do a brief introduction of my topic. The aim is really for us to engage in a conversation than me just lecturing. As you had said in my bio, I had been an instructor for many years, so I do have tendencies of teaching. So try and stop me, interrupt me, ask questions. But basically starting to the topic, protect your family and why is it important to have a will. I think it is self-explanatory. The very first reason is that you need to protect your loved ones to have a will. And to really understand why it is important to have a will is that if you do not have a will, the law determines who then inherits your estate. And and you have no choice. And sometimes I always say people must understand what are the disadvantages of not having a will. Then appreciate what are the advantages of having a will. So if you don't have a will, we say in our law you die intestate. So if you are this is what the intestate succession says. This is the law that says what should happen to people who die without leaving a will. If you are married.
Sis Lumisa, can I please disturb you a little bit? May I please ask everybody who is on the Zoom platform to make sure that their mics are muted? Because when you are busy going on with your business, you are disturbing the person who is doing the presentation. And people who are going to be viewing this video are not going to be able to hear what the presenter is saying. So please, everybody, make sure that you mute your mic. Thank you so much. Thank you, Sis Lumisa.
Thank you. So, as I said, I wanted to start with the implications of not having a will, then we can appreciate why it is important to have a will. So, if you don't have a will, the law is very clear. This is what will happen. So, if you're a married person, you don't have children, your spouse inherits everything. That's the law. There's no two ways about it. If you are married and have children, then it becomes a bit complicated. It depends how you married first. If you married in common of property, you will first get the half share by virtue of the marriage in common of property, and then the law says that you will then inherit 250,000 or a child's share, whichever is greater, depending. So, for example, if the net estate is, that is after we've taken the half share, let's say the estate is at 2 million rand, you get your half share of 1 million rand, your spouse, then there's 1 million rand to be divided, and there are 4 children and 1 spouse. So for purposes of calculating the child's share, we take the spouse as a child. So you take the 1 million rand divided by the number of children plus the spouse, so it will be 4 plus 1. So 1 million divided by 5, so each one gets 250. So the spouse and each child, in fact, get 200,000. So the spouse will get 250,000, and the 750,000 would be divided amongst the children equally. Whilst I'm on that point, it is also important to know that in our law, in terms of the Intestate Succession Act and in our law generally, a child inherits from their biological parent. And all children are treated equally, whether they were born from the marriage or not from the marriage. So it doesn't matter whether the child was born out of wedlock or in wedlock, as long as the child is a child of the deceased. So the child inherits from their biological parent. So if a child is formally adopted, then the child inherits from the adoptive parents and not the biological parents. So by adoption in law, you become equal to a biological child. But if you are now married, but married out of common of properties, there's no half share to be determined. So what you would inherit is the 250,000 or a child share, whichever is greater. So we'll take the 2 million rand, divide by 5, the number of children. So each one gets 400,000 because 400,000 is bigger than 250,000. That is the law. That is just what it says. If you were not married, but had children, all your children will inherit in equal shares. So that's the third scenario where there's no will. The fourth scenario is where you are not married, there are no children. The law says then your parents must inherit in equal shares. In case your parents are deceased, the law says then they are descendants, meaning which your sisters from the mother's side or brothers from the mother's side or your siblings from both sides will inherit. So your estate is divided into 2 halves. One goes to your mother's side, one goes to your father's side, and the descendants from your mother's side, they will inherit equally. This is when your sisters and brothers will inherit. if you're born from the same mother, and then your siblings from the father's side could inherit. This could include, for example, your step siblings, for example, because they are the descendants of your biological father. So that's what the law says if there's no will. So you have no control whatsoever. The law says that's how your estate will devolve, and that's how it will evolve. And only in rare circumstances where there are no nearest relatives will it then be forfeited to the state. But it's very rare, especially in our African context. So therefore, it is important to have a will so you can determine and decide while you're still alive how you want your estate to be divided. So that's the most important thing. And remember, if you have children, they inherit equally, whereas in fact, in your will, you could determine, for example, that the youngest child, because they may have more needs than other children who may be self-supporting, you may want them to inherit a greater share of your estate. So that's why it's important to have a will, because you can determine who your heirs are. You can also determine the portions in which they inherit. So, for example, you could decide that for child A, I give them 10%, for child B, 20, C, and so on and so on and so on. And basically, to understand, a will is not a complicated document. Sometimes we think must be drawn by lawyers or must be drawn by professionals. Yes, it's important that it is drawn by them, but it can be drawn by anyone as long as the requirements are met. And I wanted to deal with those requirements. First of all, it must be in writing. So you can't just take a video of yourself and express your wishes. Our law doesn't consider that a will. Well, it's merely your wishes. So it must be a document, it must be in writing. It must state that it is intended to be your will. For example, it would just have the heading last will and testament of Mr. Nongogo or will of Mr. Nongogo, then we know it is a will. And the structure of the document, for it to be clear that it is a will, it's better that it has that heading. I'm not saying if it doesn't have a heading, it won't be considered a will, but when you say it's a will, then everyone's clear that it is a will. The most important thing, these are the things that must be contained in a will. So you must state it is a will, so it must have that heading that it is a will. The other clause that we normally have in the will is what we call a revocation clause. It's a clause basically that says you intend this will to be your last will. That is, you revoke all wills you had made before. Because in law, the will that applies on your death is the latest one that you drew. So it's very important that you have a clause that revoke previous wills. This is just to prevent a situation where we're not sure if we have a set of two wills and they are contradictory in terms of their content. And yeah, we need to show which one you intended to be the last will. So we want you to say this is the last will. You also must state in clear terms that you revoke any previous will you may have made. So we know that this is the only document that would be used to liquidate or wind up your estate. So it would have the revocation clause. The second or most important clause, or one of the most important clauses in the will, is to appoint a person we call an executor. The duty of the executor is basically to carry out your wishes. This is the person who will, on your death, report your estate, obtain what we call letters of executorship. This is the person who will be responsible for winding up your estate, closing your bank accounts, paying your liabilities, and distributing the estate to the people who you've nominated in your will as heirs. Thirdly, you must appoint heirs. It's very important that you appoint heirs, because this is how we know how you want your estate to devolve. So you appoint your heirs. As I said, in law, we've got what we call freedom of testation. So you choose who you want to bequeath your estate to. So there's no limitation as long as your wishes are not contrary to public morals. So you can, some people leave, you don't have to leave to your family, you can leave to any other loved ones, relatives, helpers, charity, the church. You must consider leaving something to the church in your passing. So you've got a freedom of gestation. So you can appoint your heirs. There's no limitation. As I said, you can appoint as many heirs as possible. For example, you can also create what we call legacies. You don't appoint someone as an heir, but you want to leave your watch to someone special, or jewelry, or some an amount of money to someone, or whatever prized possession or sentimental possession you want to a specific person. We call that a legacy, that you just leave just that one thing to this person. And then you appoint the heirs. The heirs are the people that will inherit the residue, that is the balance of the estate, whatever is left. Okay. So when you appoint heirs, you can, as I said, determine what they inherit. You can, for example, in the case of children, you can say, I bequeath my estate to all my children in equal shares. You don't have to state what they are inheriting. So whatever you own, they will inherit in equal shares. Or you could say, I bequeath my car to my child A, my cash to B, my house to C, but you must deal with the residue of the estate, because remember, our circumstances change. So this year I may have a car, I may have a cash, I may have a house, but in the next year or so I may acquire another car and another house. So my will should deal with everything that I own at any particular time. So we would have a clause that deals with the residue, that I bequeath the residue. That is, whatever is left, I haven't mentioned in particular terms, or I haven't left to a particular person, that the residue must devolve to the heirs in equal shares. This is just to prevent you from dying partially testate and partially intestate. So you could die partially testate in the sense that you've said in your will, I bequeath the assets I have now to A, B, C, and D, and then I acquire more assets and I haven't dealt with those assets in the will, and those assets will now devolve by way of intestate succession, because I haven't nominated beneficiaries for those assets. So the way to avoid that is that your will should say, the residue of my estate will devolve to these heirs in this particular way. So this is just to make sure that whatever you have will be dealt with in the will. So even if you acquire more things or less, we can still wind up with your estate in terms of the will. So this is when perhaps it becomes necessary that you have your will drawn by a professional person. But as I said, any other person can draw it. In fact, you can go to a stationery shop and buy a pro forma will. You just fill in the details. But I will come to the requirements for it to be valid. But I'm just going through the contents at the moment. So you devolve, you bequeath your estate to your heirs. I also like to, we also recommend that if you have children who are young, children of course are younger than 18, that you must also appoint a guardian. In law, biological parents are automatically guardians of their children, but in the absence of a biological parent, it's important that in your will you also appoint a guardian. This is the person who will now make a decision for your child. Okay. So you can appoint a guardian if they are minor children. We advise that you appoint a guardian. It could be anyone that is, of course, a person that you would trust, that they will look after the best interests of the child until they attain the age of majority. You can also decide to create a trust in the will. This is when you don't want whoever your beneficiaries are to have access to all what you have bequeathed to them. So you may want to impose conditions that whatever you've left with them will be held by trustees who you will appoint in the will until they reach, for example, age 25, or until they obtain a tertiary qualification, whatever conditions that you want to have in your will before your beneficiaries have access to the inheritances per se. The other, then the trustees, you can then determine in your will what powers they will have. For example, you normally give them powers to pay for their day-to-day needs, education, living allowance, and so on and so on, and make those decisions. You can also, I also encourage this, that in your will you also should state your wishes regarding your burial. For example, if you want to be cremated, or if you want to be buried, and where you would want to be buried, so that there is no dispute after death as to what your wishes are. Okay, because if you don't have a will, there could be a dispute after your death as to how you should be buried or who should be responsible for your burial or funeral. So in your will, you could, I encourage that people state what their funeral or burial wishes are. As I said earlier on, you could impose any conditions. For example, you could bequeath a sum of money to a university or a church, provided that they will, or you can donate land, provided that they will build a church or a school building, or whatever you want done with what you've donated in your will. We also recommend that in your will you create a clause that protects your beneficiaries from the provisions of the Matrimonial Property Acts. That is, if they are married in common of property, you have a clause that says whatever they inherit will not form part of their joint estate, so that it will remain their separate property. Or that if they are married out of common of property with accrual, you also direct that that accrual system will not apply in regards to your inheritance. This is now to protect, usually by parents, their children, in the event that they get married, that at least what they bequeathed to them may not be claimed by their spouses. For example, in the case of a dissolution of that marriage, that what they inherited from you will remain their separate estate and won't be part of their joint estate. So as you can see, the importance of having a will is to protect your loved ones. And you've got like a wide choice. I've just given you like the basic structure of a will, you know. And as I said, because of freedom of gestation, you could include whatever you want as long as it's not against the law. And yeah, any conditions you can impose in your will. As I said earlier on, a will can be drawn by any person, but these are the requirements for it to be valid. So I've already stated the first one, that it must be in writing. The second one is that it must be signed by the person drawing the will. We call them a testator. If it's a man, a testatrix. If it's a woman, but it's the person who's drawing the will. Okay, I think trying to use simple language. So it must be signed by that person at the end of each page, and it must be witnessed by two witnesses who are 16 years or older in the presence of each other. So when you're drawing your will, it would be signed by the person drafting the owner of the will in the presence of two witnesses who will also sign in the presence of each other. So when you execute a will, so when you actually sign it, there must be three people: the person signing the will and the two witnesses, and they must sign in the presence of each other. The reason for that, the witnesses don't have to know what your will says. All they are there to do is just to witness that the will, the document is indeed the will of the person who made it. So they are there to just witness that the signature is your signature and that the will is your will indeed. They need not know what is contained in the will. While I am there, our law prevents witnesses from benefiting from a will. So if anyone, if you want to benefit anyone, make sure that they are not they are not a witness in your will, because the law, as I said earlier on, the law tries to protect the person making the will to make sure that they are not unduly influenced. So, for example, if I'm your witness and I could have somehow influenced you to leave things to me. So this is what the mischief the law is trying to protect. But the witnesses ideally should not be beneficiaries in a will. In fact, they shouldn't be. They are disallowed to be beneficiaries, if only in exceptional cases and only with the leave of the court will they be allowed to inherit. But ideally, as I said, if you want someone to be a beneficiary in your will, don't make them a witness. Get people who have no interest in the contents of your will to be witnesses. Of course, the person making the will must have capacity to make a will. They must not be unduly influenced. They must be in the right state of mind, sound mind. So, for example, a person who's mentally incapacitated cannot make a will because they lack the capacity to make a will. So sometimes you do find that there is a will that ticks all the boxes, that when you look at it, it complies with all the requirements. It is written down, it is signed by the testator, it is signed by the witnesses, it looks valid, but it may be invalid because, for example, the person didn't have capacity at the time, or the person was unduly influenced. So it's not freely and voluntarily made, so it could be challenged. So, but we wouldn't know that it's other people who would have known of the state of mind of the person who made the will, who challenged the will. So a will, once it complies with those requirements, it is then considered valid, is accepted by the master, and then the master of the High Court will then appoint the executors in terms of the will, and then the executors will be given what we call letters of authority or letters of executorship, documents giving them authority to do whatever needs to be done to liquidate the estate. And the reason why we actually liquidate or wind up estates is that in law, once you die, we need to wind up. There must be nothing left that is still in the name of the deceased person. So if they had property, it must go to the people who are entitled to it in terms of the will, if there's a will, or in terms of the Intestate Succession Act, if there's no will. If there are liabilities, you still owe the bank, and so on and so on. Those liabilities must be paid. And after we've paid all the liabilities, then we devolve what is left of the estate. So the purpose is that once a person has passed on, their affairs in life are wound up. Nothing is left as an obligation. Nothing is left still in their name. And it goes to the people entitled to it. So if you have a will, that's the other thing, is that at least someone must know that you have a will. So it doesn't help if you have a will and it's hidden in a very obscure place in your house and no one knows where the will is, because when you die, no one knows. Your estate will be reported as if it's intestate. So there must be someone who knows where your will is. So it's easy when your will is drawn by a professional because they keep the original will, which will be required on your death. But even in that case, you still say, at least give us two people in your family or close people to you who would know where the will is in the event of your demise, and then they can come and say, we understand that the person had a will. Again, as I said, people's circumstances change. So even if you have a valid will, it's important to review it at least once a year, just to check if it still expresses your wishes at the time, because you may have drawn a will and your circumstances may have changed and you may want to change the contents of your will. Especially in the context of married people or spouses or partners, you may have bequeathed your estate to your partner, your spouse, because there is a relationship, and a few years down the line, that relationship is dissolved and you haven't changed your will. And if you don't change your will, the law says this is what we intended, and that former spouse or partner will still inherit your estate, though everyone knows that your circumstances were such that you no longer intended them. But because it's your will, it has to be carried out. The law only allows you 3 months after a divorce, basically, to change your will. So if you have an existing will and your marriage is dissolved by either divorce or annulment, and the testator dies within 3 months of the divorce, that is before 3 months after the divorce, then the law protects that estate and says that that ex-spouse is deemed to have predeceased, to have died before the testator, so they will not inherit. So basically, the law allows you 3 months after divorce to change your will. If you don't change it after 3 months, then the law presumes that you intended to inherit your ex-spouse still. So there's some of the important things that we think people should take into account. So I say, as soon as the circumstances change, revisit and update your will accordingly. So you can do one today and one tomorrow. You know that there is no limitation. As I said, there's freedom of gestation. Again, it's just a practical thing now. It's important that you date your will. It's not a requirement. Even if it doesn't have a date, it's still valid. It's not one of the requirements, but it helps in case there is more than one will, so we know which one is the latest. So okay, I must say there are some questions in the chat. So if there is no date, we would not know which one is we must carry out, so we'd then fight about it. There is, okay, say I must increase my volume, so I'll try to do that. I'm not sure how. Is that good? No.
I can hear you clearly. Maybe the person needs to increase their volume on their device.
Okay, now that's fair. So, B, you asked, does it mean that if you don't change the will within 3 months, you can't change it afterwards? Yes, you can. It's just that if you were to die without having changed it, then it still applies. Okay, so the 3-month period is just important for you to say that if you want to change it, make sure you change it as soon as possible after the divorce. Otherwise, you can change it years afterwards. It's just that we don't know when death strikes. That's the whole thing about wills. We should always be prepared because we don't know when one will pass on. But the short answer is that you can change it many years afterwards. So you're not limited to the 3 months. It's just for the 3 months you are protected. It will be interpreted as if your spouse is not there. I think I've covered the basic structure of my talk, the most important things, but of course I will prefer that perhaps we engage in more practical questions, or things that are not clear at this stage. Slide. Thank you.
Yeah. Thank you so much, Misa. As you were talking, you were actually answering some of the questions that I think a lot of people have regarding your will. Let us first start about not having the will, which is where you started with your talk. The effect and the impact that you will have, or your estate will be subjected to if you do not have a will. The understanding is, and I'm glad that you went down, the understanding is that, for instance, let me make myself as an example. I have a will, my husband has his own will. We have two separate wills, right? So if we both die at the same time, God forbid. So you and your spouse, maybe the whole family perishes at the same time. And maybe in your will, you did not make provision for anybody else outside of your family inheriting your estate. What happens? Or can couples or families include clauses, that in case we die at the same time, then everything must go to the Methodist Church of Southern Africa, as an example?
That's a very important question. I should have actually addressed it. It's very important that it's important that you do create alternative beneficiaries. So, for example, you bequeath your estate to A, but in the absence of A, this is what should happen. Okay. If you have a will, the law says that if you had left your estate to your children, for example, and for some reason your child predeceases you, that dies before you, the law says that their share will go to their children, so to your grandchildren automatically. That's what the law says. But that's only in the case of descendants of children. But in the case of other people, there is no such a rescue mechanism, as it were. So it's important to have alternative beneficiaries. And what you also you touched on is also important, because sometimes, especially spouses, do have what we call joint wills. So we have one will. My husband and I have a joint will. Typically, would leave our respective estates to each other, and then in the event of us dying simultaneously at the same time, or within 6 months of each other, then we appoint another executor and devolve beneficiaries, usually our children, and so on and so on. So you do have a joint will, but a joint will is interpreted as the first will, as the will of the first dying. So meaning which, if we have a joint will, me and my husband, but he passes on first, that will only applies to his estate only, because he's the one deceased and not me. Okay. And if I don't make a subsequent will, that will apply in case of my subsequent death. So spouses can have separate wills, they can have joint wills, but sometimes we find that spouses have joint wills, then the next day the other spouses goes make a separate will.
Yes.
And the other spouse doesn't know about it. They will only know it after death. So you can have a joint will, but there's nothing preventing the one spouse, after having a joint will, to make a separate will. So the joint will only be interpreted as the will of the survivor, basically, because the deceased who had made a subsequent will, that will then apply. So nominating or appointing alternative beneficiaries is very crucial, because you may have a will, but then it's impractical to implement, because like all the people you had chosen are not there anymore, and they are no alternate beneficiaries. So it's very important. But that is in the case of a will. And if even if the people that you've nominated are no longer there, then your will be interpreted as if there was no will, that we will go to what the Interstate Succession Act says we must do. Because remember, the Interstate Succession Act says that if I only gave you 4 scenarios, that it will go to the spouse and children only, and then the parents. Then if parents are not there, then it goes to your siblings from both the mom's side and siblings from the dad's side. And if they're not there, it goes to their children, meaning your nieces and nephews, and whoever is there. So it will, in terms of the Intestate Succession Act, there is going to be someone's descendants. It's very rare that you would find that we don't know who would benefit. In my all years as an attorney, but I think only one situation where the estate was actually forfeited to the state. In fact, it was a case of someone who was a foreigner, and no one could trace their relative, because remember the Intestate Succession Act works on the basis of biological relations. So it's the people closest to you. Whereas the will, in terms of the will, you could choose anyone. You don't have to be related to them.
Okay, Sis Mumisa, Zanda is asking a question. Zanda says, what happens if you die interstate and you are married out of community of property?
Okay. What happens in that case if you don't have children, but you only survived by your spouse inherits everything, though you are married out of community of property. Okay? Because that's what the law says. But if you have children, what the spouse will inherit is 250,000 at the moment, or a child share, whichever is greater. As I said earlier on, we take the value of the estate, let's say 2 million, divided by 3 children by one spouse, so say 4. If it's 2 million and there's 4 of you, the spouse and 3 children, each one gets what? 500,000. So your spouse gets the child share because it is greater than 250. So everyone gets 500,000. But let's say if the estate was 400,000, there's a spouse and 3 children, so the spouse gets 250,000, and the children share the 150,000, so they get 50,000 each. Or if the estate was really small, the spouse to whom you married out of community of property would inherit